Hello. Hello. Hi, everybody. Welcome in. Welcome in. Let me see here. Let's get us going. Oh my gosh. Hello. 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 Welcome. Welcome. All right. Whew. I think we're close enough so that everyone can see. But just let me know if you need it to be any closer. Hello. Hi. Hi, Kimberly. Hi, Miss Julie. Adania, Dania. Good to see you. So unique. Hello. 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 Hi, Lee. Hi, Michelle. Katie, good evening. Amanda, yay, hello, hello. Yes, we made our Tuesday goal over here on the tube. Very happy about that. Tonight for sure. Hi everyone. Allison, hello, Deb, Kristen, hello. Bruce Wayne's mother, hello, welcome. Well, welcome in. I had planned to do something a little different tonight, but then boom, the Supreme Court's like, well, we got stuff we're gonna screw up. So, oh, Kimber, okay, great. Thank you for telling me. Oh, last Tuesday, I know, Katie. Oh my gosh, I tell you, I've tried so hard to figure my schedule out. And what I'm thinking is I've got to kind of go a little easier on Tuesday so that I'm just all powered up for Tuesday night. Which is what I did today. It was my new method, and I think that's going to be a winning combo here for sure. Hello, good evening, good evening. Yes, Shirley. Al, hello, hello, hello. Just popping in. Oh, no worries. Oh my gosh, of course. You got to take care of yourself, Tay. Oh my gosh. Oh my goodness gracious. Oh, oh my gosh, I'm wishing everyone there the very best. So difficult. Such a difficult situation. Yes, no problemo, no problemo. Yeah, we kind of do a little switcheroo when we're over here. The format's a little bit different, and our names can sometimes be a little bit different too. So, hello, Vicky. Welcome, welcome. Welcome in, everyone. I know I was kind of late posting over on the talk that I was going to be live here tonight, but I did put it in my little bubble, you know, the little bubble that's at the top. So I found that was helpful, at least for some people. Hello, hi Kaya. I hope you're having a great day. Hope everyone's doing all right overall. It's been, you know, we're feeling the, we're feeling it right now, everyone. I think with the Supreme Court cases that came down just a few days ago, and then the 4th of July situation, which is basically, you know, trying to figure out what's happening. And then rolling into this week, yeah, it's been a bit rough. It's been a bit rough, but we will power through. We will power through. Yes, Shirley. Oh, thank you. Good. I'm so glad. Oh, you saw? Okay, excellent. Love that, Kristen. Love that. Love that. So yes, I figured let's go ahead and talk about this one tonight and see what we can do. So first off, I'm going to try to make it so that the camera isn't focusing and unfocusing. I've done what I can at this point, but I'm maxed out on my knowledge. But I wanted to take everybody through. We did get a decision from the Supreme Court today, and here's the decision. It's 2 paragraphs. It's 2 paragraphs, unsigned, so we don't know who signed it. And then Justice Sotomayor concurred in the granting, and then 1 little paragraph here with how she's concurring. And then Justice Jackson wrote 15 pages dissenting. Here, let's just make sure I get it. 15 pages dissenting, and she's not messing around. So we've got some strong feelings here from Justice Jackson. I've got a double here. Oh, I know, malarkey. Oh my gosh, it's one of my favorite words. So I thought let's go ahead and dive into the law. Uh, I think we're okay. We're okay. Again, anytime we're dealing with a stay or something like that, you have to remember we are not in the final decision phase. We are at the very beginning. So the discovery phase, the trial phase, all of that stuff to determine whether or not the lawsuit wins or loses, we haven't even scratched the surface of it yet. And remember too, and this is so important, everyone, remember all of these lawsuits, they take some time. They take some time to get all the way through, right? Because as you've seen, we're only in this preliminary injunction state area, right? We're barely even tipping into discovery. The reason I remind you of that is it can take a couple years. It can take a couple years for these cases to make it through the process. And by the time that's even done, then the appeals take time, right? And then going back down and changing things, and that takes time, and then going back up again. So it's very, very likely, in my humble opinion, that a lot of these cases will pass through, first of all, the midterms, of course, which is going to be huge. And then also when this presidency is over, right? So I went through the Trump v. Hawaii case a couple years ago. I did a post on it. I posted it today just to remind everybody the very first pieces that Trump did in his first administration had to do with the travel ban. And by the time that made it all the way up to the Supreme Court and decisions were made, they didn't even finish. They didn't even get to fix what needed to be fixed. He was out of office. So I really, really want to remind everybody about that, because although the system is slow and we do have some exigency on certain issues for sure, like El Salvador and such, but all of the other splinterings of everything else here, because we're over 300 lawsuits, not all of these are going to make it to the end, right? And then we'll see who's in charge of the Department of Justice at that point. So it could be, the cases are voluntarily dismissed at that point. Just keep that in mind. Now, we definitely still have to keep watching and make sure everything's going okay, but just keep that in mind. But I wanted to start tonight by going through the law that's in question here. As I continue to go through all of the executive orders and I continue to look at the abomination of the kind of language that's being used, I will continue to share with everyone. So let's dive in. I will go ahead and pull this out. I did not annotate even tonight because I thought let's kind of do it together. And all right, so let's take a look. In the very beginning here of the decision, so we've got, let me read through this. It's only 2 paragraphs again. I've got the application for stay presented to Justice Kagan and by her referred to the court as granted. On May 22nd, preliminary injunction entered by the United States District Court for the Northern District of California is stayed pending the disposition of the appeal in the United States Courts of Appeal for the Ninth Circuit and disposition of a petition for writ of certiorari if such a writ is timely sought, right? So the district court had said, you can't do this. And so what they're doing is they're pausing the district court's order saying you can't do this during litigation. Should certiorari be denied, the stay shall terminate automatically. In the event certiorari is granted, the stay shall terminate upon the sending down of the judgment of this court. The district court's injunction was based on its view that executive order number 14210 and a joint memorandum from the Office of Management and Budget and Office of Personnel Management implementing that executive order are unlawful. Because the government's likely to succeed on its argument that the executive order and memorandum are lawful, and because the other factors bearing on whether to grant a stay are satisfied, we grant the application. So as we all remember, we're going to be looking at the winter factors, which we all know plenty about at this point in time, right? So there's that. And so here we express no view of the legality of any agency, RIF, and reorganization plan produced or approved pursuant to the executive order and memorandum. The district court enjoined further implementation or approval of the plans based on its view about the illegality of the executive order and the memorandum, not on any assessment of the plans themselves. Those plans are not before this court. So again, the Supreme Court saying this is very, very narrow. This question on whether or not the executive order and memorandum are legal is the only thing that we are going to answer, because that was the justification for putting the injunction into place. All right, and they're pausing that. All right, does everyone follow me on that? I'm just trying to make sure here that I've caught everybody. Hello, Chris. Hello, welcome, Kathy. Hello. So let me take a minute here to just kind of annotate this out first. And I tell you what, these executive orders are just something else. Just something else. Section 3 down here. I am trying to make sure to go through as many executive orders as I can, because they really just are something else here. All right, I'm just annotating. This is how I pull all the text out if you're new here, and make it a little bit easier to understand, for not just for you, but for me too, because things can get tangled up if we don't have them set out properly. So, and I've always found that legal documents are overwhelming unless they're like brightly colored, because that makes it easier. Like, oh, this isn't going to be too bad if it's got rainbow colors, right? And then later it's like, no, it was this bad, but that's all right. We'll get through it together here. So let me just, almost done here, everybody. Pulling this in. And see, and then section 5, which we really don't ever need to go over. Section 5 is about the rule is not trying to undermine any other rules, which is just like, what? So you have to put that in here. So I don't really take everybody through that one. All right, here we go. We are annotated, everyone. It definitely helps. I think so too. Because, you know, some people can just look at a block of text and be like, okay, well, that's that. But that has never been my style of learning and understanding. So as a visual learner. So here we go. Let's take a look. We're going to just go through this executive order that was issued, and then we'll go through the memo next, and then we will dive into where Justice Sotomayor and Justice Jackson are at. So Executive Order 14210 of February 11th, 2025, implementing the President's Department of Government Efficiency Workforce Optimization Initiative, right? So this is the DOGE stuff. By the authority vested in me as President by the Constitution and the laws of the United States of America, it's hereby ordered, Section 1. So here's our purpose: to restore accountability to the American public. This order commences a critical transformation of the federal bureaucracy. By eliminating waste, bloat, and insularity, my administration will empower American families, workers, taxpayers, and our system of government itself. All right. Next, our definitions. And this is something that you have to really be careful about with these executive orders, because again, one of the biggest things the administration is doing is redefining words, taking words that everybody knows what the meaning is and kind of twisting it around into what they want it to mean. So we have to be very careful with our definition section. So here's A. Agency has the meaning given to it in section 3502 of Title 44 United States Code, except that such term does not include the executive office of the president or any components thereof. So he's just right off the bat saying, I've got special powers. Agency head means the highest ranking official of an agency, such as the secretary, administrator, chairman, or director, unless otherwise specified in this order. Okay, Doge team lead means the leader of the Department of Government Efficiency team at each agency as defined in the Executive Order 14158 on January 20th, establishing and implementing the President's Department of Government Efficiency. All right, employee has the meaning given to it by Section 2105 of Title 5, United States Code. This is always nice when they're actually using the code sections. We appreciate that because we know then that it's not being made up. That's I can appreciate that. It includes individuals who serve in the executive branch and who qualify as employees under that section for any purpose. Immigration enforcement, all right, means the investigation, enforcement, or assisting in the investigation or enforcement of the federal immigration law, including with respect to federal immigration law that penalizes a person's presence in, entry, or re-entry to, or employment in the United States, but does not include assisting individuals in applying for immigration benefits or efforts to prevent enforcement. That's important right here. So it does not include, all right, assisting individuals, right? So that's important to note. To prevent enforcement of immigration law or to prevent deportation or removal from the United States. Law enforcement means 1, engagement in or supervision of the prevention, detection, investigation, or prosecution of, or the incarceration of any person for any violation of law, or 2, the protection of federal, state, local, or foreign government officials against threats to personal safety. All right, temporary employee has its meaning given under 5 CFR Part 316. So again, that's another code definition. And reemployed and annuitant has the meaning given to it in 5 CFR Part 837. I literally do not hate anyone except, oh my goodness, I know everybody, I know. And the thing is too, there's truly no escape. There's no escape. Some things have just been so, have been changed so much. Now we can go forward and fix the changes, but it's just been so much that it's going to leave a mark. That's kind of how I look at it. And his entire administration, right? Right. You know, my question to everyone, I was thinking the other night, I wonder how much his cabinet gets paid. Do we know by chance? Do we know how much each of those cabinet members are paid? Because they're like billionaires, and I'm just curious. The American tax money is going to pay billionaires for their cabinet work. I'm curious about that because, you know, the presidents before have donated their salary, and I'm wondering if that's what the cabinet members are doing, or if they're like getting paid and they're wanting more money. So is that kind of being worked out? You know what I mean? Like they're all of his friends and stuff. So I keep thinking like, well, how are they getting paid? Because all of them are in it for, you know, they're business people that want to do what they want to do. So I'm just curious. 205,700. All right. Trickle down economics. True. All right, very interesting. Okay, so yeah, so they're probably like, we're not getting paid enough for all the work we're doing. Because the one thing about these executive orders is they are setting out a huge workload now for everybody. Everybody in the cabinet is being ordered to do all kinds of stuff. And I was reading through last night on, you know, the Secretary of State, various things that are due by certain dates, and I keep thinking like, that's a heck of a lot of work. That's a lot of work. Meme coin under the table. Well, right. I mean, they're making connections, right? So by making those connections, those will serve them in the future. But on the other hand, also what, you know, and the other thing too, I keep thinking is Trump probably isn't keeping track of all of these different memos and assessments that he's asking them to do. Or even if he, I mean, it sounds like something he would request because of his micromanagement style. But I mean, we've got 200 executive orders, and at least 75% of those are requesting reports. And I just think it's interesting. Level 1 positions. Okay, right. Yeah, so again, I mean, that's like a drop in the bucket for these people. I'm just wondering if they're like, well, not worth it. And then, because if it's not worth it, then they leave, right? Level 2 is 203,700. Ooh, all right, good to know, good to know. Thank you so much, I appreciate that. Yeah, it's kind of an ongoing question, because if you can make somebody's position not worth it anymore, they're like, I gotta go. We'll see what happens, unless of course they're being blackmailed, which is what my thought is. Wonder if they're going to donate their salaries. Right. And again, Cynthia, that was like a mess for those of us that remember that. All right, so here we go. Diving back into it. Reforming the federal workforce to maximize efficiency and productivity. Here's section A here. Hiring ratio. Now there may be something in here. Let's look. We're going to be playing like Where's Waldo to see if there's something in here that's not harmful to people. So we'll kind of keep that out. That's our goal. Pursuant to the presidential memorandum on January 20th, the hiring freeze, the director of the Office of Management and Budget shall submit a plan to reduce the size of the federal government's workforce through efficiency improvements and attrition. So that's the plan. And the plan shall require that each agency hire no more than one employee for every 4 employees that depart. So they want a 1-to-4 ratio here. So again, those who haven't been canned are basically now doing the work of 4 people, right? And they probably already were doing the work of multiple people. So one person is doing the job of 4 people. Consistent with the plan and any applicable exemptions and details provided for in the plan. This order does not affect the standing freeze on hiring as applied to the Internal Revenue Service. This ratio shall not apply to functions related to public safety, immigration, enforcement, or law enforcement. All right, so we've got some exceptions here. I think that's important to note. So related to functions related to public safety, immigration enforcement, or law enforcement. So they are not in the same ratio here. Agency heads shall also adhere to the federal hiring plan that will be promulgated pursuant to the Executive Order 14170 of January 20th, reforming the federal hiring process and restoring merit to government service. So that's another executive order where he set out what he wants to do about that. Right. That's a good question. Good question. That's the other thing too, though, right? Is that they're saying, well, nobody in law enforcement, but what exactly is law enforcement, right? That's the definitions issue. If it's not firmly set out, then we don't know exactly what they're talking about. All right, here's the hiring approval. So 4-to-1 is the first piece. And hiring approval. Each agency head shall develop a data-driven plan in consultation with its Doge team lead to ensure new career appointment hires are in the highest need area. All right, so that's, I think here it's important to note as we go through this what's actually happening. So they're asking the agency heads here to develop a plan. So they got to make a plan. That's number 1. So under section B. So let me ask the chat then. Are we okay about the hiring approval with just section B just by itself? We'll go into the subsections in a minute. But each agency head is to make a plan. Right. Power not working hard. Exactly right. Right. Like, I'm okay with making a plan. Okay, no plan. No plans can be made. All right, that's all right, if that's how you feel. Like, I don't mind the research gathering process. The implementation is worrisome, but the idea of making a plan itself, I'm, like, all right, whatever. All right, well, let's look at the subsections. All right, so we're making a plan. Number 1, this hiring plan shall include the new career appointment hiring decisions shall be made in consultation with the agency's Doge team lead, consistent with applicable law. So they're trying to say, not under Doge. What does Doge know? And true, good point. I don't trust the heads of these departments. All right, that's a good point too. It shall include new career appointments. So they're saying career appointments rather than, partisan appointments. And that just means that it's just going to be, they're going to try to keep them hired for a really long time. With consultation of Doge, right? Agency shall not fill any vacancies for career appointments that the Doge team lead assesses should not be filled. So that's a huge shift of power. So agency heads then will have to do what Doge tells them when it comes to filling positions. Like that's a huge power change here, unless the agency head determines the position should be filled. Well, now wait a minute. That's just rubbish. Now hold on, let's read this again. Agency shall not fill any vacancies for career appointments that the Doge team lead assesses should not be filled unless the agency head determines the positions should be filled. What is this? So, I mean, it's just like not automatic. The agency has to go through like position by position in order to make that determination. So this is like a micromanagement situation again. So even if the position they've hired people for, 80 years, it doesn't matter. The agency head has to make that determination. Is that what you're getting? Trust me, bro. Yeah, we have a lot of that. Read a few more lines. I know. Well, exactly. All right, interesting. All right, number 3, each Doge team lead shall provide the United States Doge Service Administrator with a monthly hiring report for the agency. Again, we're just getting all of this micromanagement stuff going on. So this one's saying Doge will have to send a hiring report out. So they've got to create this and make that. So our 3 pieces here, they need to make a plan, a hiring plan. They then need to assess each and every position in that agency, whether or not someone should be hired or not. And then they have to set out a report. So 3 steps here. Exactly, Estelle. That's exactly right. You've got to fill out all this paperwork saying like, I, have allegiance here. Concerned with waste. I know, Kaya, right? Is anyone seeing how crazy this is? I mean, yes, I'm sure we all are. But look at this. And look at the tasks here. We've got 3 tasks in order to have hiring approval that fits into the plan. So we've got 1 plan here, 2 plans, then we have the assessment of every single position, and then we have a report that's done monthly. Like, that's a lot. Who's even running Doge? Good question. Yeah, exactly. We don't know who that is. So, all right. So B is a lot of work. Here we go. Reduction in force is C. So reduction in force. Agency heads shall promptly undertake preparations to initiate large-scale reductions in force. So RIFs, consistent with applicable law, and to separate from federal service temporary employees and reemployed annuitants working, that word's going to drive me crazy all night, everyone, working in areas that will likely be subject to the RIFs. Undertake preparations. So we don't know what that is. They need to start preparing for downsizing. All right. All offices that perform functions not mandated by statute or other law shall be prioritized in the reduction in force, including all agency diversity, of course, because you don't know how that works. Equity and inclusion, so DEIA, right? So no DEI stuff. All agency initiatives, components, or operations that my administration suspends or closes. So let's just highlight that. So he's saying, we're going to cut a whole bunch of stuff. And all components and employees performing functions not mandated by statute or other law who are not typically designated as essential during a lapse in appropriations as provided in the agency contingency plans on the Office of Management and Budget website. So this, I believe, means any non-essential person, right? Is that what everyone else is seeing? Non-essential workers. And non-essential are designations in the agency contingency plans, right? So that contingency plan is made by the Office of Management and Budget, and so anyone who's not essential as determined by that office. Is that how everyone else is reading it? Right, right, right. Okay, well, all right, here we go. The subsection shall not apply to functions related to public safety, immigration, enforcement, or law enforcement, right? So you've got those grounds again, except for where this is an issue. All right, subsection D, rulemaking. So this is important here. Within 30 days of the date of this order, the director of the Office of Personnel Management shall initiate a rulemaking that proposes to revise 5 CFR 731.202B to include additional suitability criteria. So the Code of Federal Regulations, all right, is not the same as the federal code, right? So this is regulations, and regulations at that level, who actually has the power to do those kinds of things. Create frivolous positions as a way to hire their friends and families. You think so, Kristen? Do you think so? Do you think that, I think that's an excellent question, because, if we just look at the cabinet, that, Trump just kind of hired friends, not family this time, but friends that he likes, and put them into positions that are already there. So it seems like most people would do that, is when an opening happened, they would put their friend into that position rather than creating. Right, right. I mean, that's a great question. I think an excellent point. All right, so here we go. Failure to comply with generally applicable legal obligations, including timely filing of tax returns. That's important. So they're wanting to add this. Again, I don't know if that's already there. Failure to comply with any provision that would preclude regular federal service, including citizenship requirements. Failure to comply with any provision. All right. You're supposed to comply, so this is already a thing. Refusal to certify compliance with any applicable non-disclosure obligations. All right, here we go. Non-disclosures, everybody. Oh, dear. All right, refusal to certify compliance with any applicable non-disclosure obligations consistent with 5 U.S. Code Section 2302. So you can see here, everyone, right? This is the U.S. Code versus the Code of Federal Regulations. And failure to adhere to those compliance obligations in the course of federal employment. All right, and theft or misuse of government resources and equipment, or negligent loss of material government resources and equipment, which should already be the law. So I don't see anything new in here, really. It doesn't seem like it's... The question is, his claims hold merit. I don't know. I don't know about that or not. I think whenever you have people in positions of power, there is this proclivity to put friends and people in that they like. I think that's always an issue with any situation. I don't think there's a way to fully eliminate that by micromanaging everything down to which person can open the door. So I'm not sure that it's not happening, because it happens everywhere. But whether or not it's a problem more so in the federal government than other places, I'm not sure. I'm ready. I'm not ready to go down that road yet. Not ready. Yes, so NDAs. Well, let's read through that again here. refusal to certify compliance with any applicable non-disclosure obligations that are consistent with 5 U.S. Code Section 2302B13. So let's look that code section up real quick, just to make sure. United States Code here, 2302B13. Prohibited personnel practices. All right, so prohibits federal agencies from taking actions against employees or applicants for employment as a reprisal for their disclosure of information that indicates a violation of law, mismanagement, gross waste of fund, abuse of authority, or substantial and specific danger to public health and safety. This provision is part of the broader set of prohibited personnel practices that aim to protect federal employees and ensure fair employment practices. All right. I wouldn't say these positions, Kristen. I would say all positions that are available. I don't think this is unique to the federal government. Thank goodness for, right. What would we do without big balls, right? Oh my gosh. All right. Oh, all right. So it looks like you're going to have any NDAs, but they have to be within compliance of the rules for personnel practices. All right. So that's a bit that's clarifying. Next, developing agency reorganization plans. Within 30 days of the date of this order, agency heads shall submit to the director of the Office of Management and Budget a report. All right, so now we've got another report here. A report that identifies any statutes that establish the agency or subcomponents of that agency as statutorily required entities. The report shall discuss whether the agency or any of its subcomponents shall be eliminated or consolidated. So this looks like the request to take a look. Like what exactly does our agency do? What laws are affected? What do the laws say? Are we organized properly? That's how I'm reading this particular paragraph. Well, hello. It's only fair when they're getting, well, right, exactly. Exactly. Hello, Killies. Oh, they know about being fair. It's a good point, too. So this here, I would have to say, and because I'm always a big fan of, let's see what's going on. And I also think that one of the reasons why a lot of this is happening, too, is because this is not someone who's been in politics or in government. So for him, like, he doesn't even know what this stuff is. And then you might say, well, he doesn't care. True. But Steve Miller also would want to know probably what's going on here. Tardy slip. All right. No problem. Oh, all right. So that's within 30 days. I don't know. I'm wondering if all of this should be available, right? So this one might be available online if we want to look it up. So I'm going to just put a note to myself here. Is this online? We'll see. All right. Within 240 days of the date of this order, the USDS administrator shall submit a report to the president regarding implementation of this order, including a recommendation as to whether any of its provisions should be extended, modified, or terminated. All right. So we have another report. So another report needs to be made and then given to the president. Right. All right. So I think that's I don't see a problem with that, but I've got to ask though. Here's my question too, though, everyone. If we're talking about, okay, we're just crunching numbers, taking a look, doing some research, and putting reports together. Do they not already do that? That's my question. Do not every federal agency keep track of this kind of information? I mean, is that not available? It seems like this shouldn't be some kind of new thing that has to be designed and started fresh for this administration. Seems like this should already be in place. I mean, right? Am I crazy? Am I crazy to think that or what? Haircut. Ooh, love it. Oh, no. Yikes. Oh, hello, Hitch. Hello, welcome. I mean, what are we thinking? Am I crazy? Okay, I'm not crazy. Kaya, I really needed that. I really needed that note put today. I really needed someone to tell me I'm not crazy. It does seem redundant, right? They should do, or is it that the current reports do not align with the ideology? I'm not sure. I'm not sure. I am right. All right. Thanks, Annette. I appreciate that. Again. Oh my gosh. Okay. Not sure why he wants to make the reports. He can't read her. Well, that's a whole nother, that's a whole nother issue, right? It should have been done before. All right. So Lee, that's exactly what I'm saying. What I'm saying here is a couple of things. First, on its face, gathering information, making plans. All right. But if you look further, is this not already done? And if it is already done, is it done in a way that he doesn't understand or he doesn't like? So he wants to make it his own way of doing it. Like this is what he wants to have done. And by he, I mean his administration. You know what I'm saying, right? So the way that it's been done up to this point is not working, or he doesn't like it. And these are just, I'm just guessing. And so he's wanting this to be done a certain way. More likely, what I think is happening is that he and his administration have no freaking clue what any of these agencies do. And so they basically are just saying every single agency needs to tell me what you do rather than doing any work for himself. That's what I'm guessing is the problem here. He doesn't understand second grade math. They haven't cracked me yet. I'm not sure, everybody. Yeah, I would think they'd already do that, right? What report is this? Oh, stop talking during class, Achilles. So we're going through the executive order right now that was called into question here. Executive order 14210. Right. Are these reports going to end up in boxes in his bathroom? Oh my goodness. Oh, it's a great question. All right. So number one, was there nothing before? Was there nothing regarding this information before? Number two, is he just wanting his own way? Wanting it his way, right? Because it seems to me in the federal government, there's so many rules regarding tracking this kind of information. So again, I don't think we're inventing something new, but it certainly is a lot of work for the agency heads too. And that's the other thing too. The agency, and again, we're keeping in mind that the cabinet is getting paid, peanuts according to what they usually get paid for their nefarious problems. But the agency head is in charge of it. The agency head's supposed to put together a plan with the Doge. Then they go through and assess every single position in that agency. Then they do a report. Then they prepare another report and make sure that there's no DEI anywhere. And then make the determination of non-essential workers. And then get rid of non-essential workers. And then go through here and make some new rules. Because apparently this stuff isn't in the rules, although it should be. I think any refusal to certify compliance with the non-disclosure obligations is the only questionable one we've got here. But do you need to make a rule to say theft or misuse of government resources is a problem? Like, do you need this rule? Like, why is that there? He wants to dumb it down. Perhaps. It's his job to read recent. Oh my gosh, so true. I need a t-shirt with that saying on it. All right, somebody make that. I will buy it. I will buy that from you. All right. So we've assessed the, most of the meat of this meal here. So, or tofu. My apologies to my vegan friends out there. All right, so let's go into section 4, exclusions. And the other thing too, though, everyone, as I go back and look at the meat tofu, I don't see a direct harm from this information. I don't see the harm when it comes to making plans and pulling in information. The 4-to-1 hiring practice is a huge problem. Now that's an enormous issue. His last term, he had to remind himself. Or the Impossible Burger. You're right. You're right. All right, here. Let's talk exclusions here. This order does not apply to military personnel. That's good. Agency heads may exempt from this order any position they deem necessary to meet national security. All right, so they've got some sovereignty here. National security, homeland security, or public safety responsibilities. So the agency heads do have some power here. The director of the OPM may grant exemptions from this order where those exemptions are otherwise necessary and shall assist in promoting workforce reduction. So, all right, so OPM also then can step in. So the head of the agency can make some exceptions, the OPM can make some exceptions, but who's in charge of the OPM? Do we know who's in charge? I mean, isn't it that Heritage Foundation fella? Oh yeah, exactly, Achilles, if not all of them, right? All of the bosses have been handpicked and put into place. Okay, is that right? Is he the dude that's the Heritage Foundation fellow? Okay. So, right, so his reliance on people loyal to him makes it so he can just say, go do this, and he can just like not have to deal with it. Meanwhile, for the rest of us, we're like, these people aren't qualified in a lot of situations. I don't know all the agency heads, but if they're anything like the cabinet, there's no experience, no knowledge of what's going on, and we're just supposed to trust that they're somehow going to figure out which exemptions are appropriate. Right? Small doses. Oh my gosh, yes. And you can't have anything salty when we're going through documents. You shouldn't trust your government, period. True story, Mike. True story. All right, well, at least there's some exclusions, I guess, to some degree. So that's that. And then here's section 5, and I won't spend time on this. This is just where they're the boilerplate language saying this executive order is not going to, be in conflict with any of the laws in place. All right, everybody. So we've got a pretty good understanding now of this executive orders. This executive order 14210 is setting out a plan for agency heads and DOJ to work together and put some reports together, put some information together that they probably already have, that he just doesn't care if they already have that information. All right, so that's what this is. And also the hiring ratio situation as well. Loyal to him, but only as far as it supports. Well, exactly right. And that's the other thing too, when we're talking about salaries, like, are they getting paid enough? Because if their benefit doesn't outweigh what they're doing, then they're going to hit the road, Jack, right? Here we go. Let's dive into the memo. So let's look at this memo. Again, this is hand in hand with this executive order. So this came out, 2 weeks after the executive order. Wait, how's my math? February 11th. Is that 2 weeks? Yeah, it's about 2 weeks. Oh, good for me. Good for me, mathing. Hello, Carrie. Hello, Desert Skies. Welcome in. All right, so here we go. Memorandum, background. The federal government's costly, inefficient, and deeply in debt. All right. If the federal government was a person, they would be so hurt right now. At the same time, it is not producing results for the American public. Instead, tax dollars are being siphoned off to fund unproductive and unnecessary programs that benefit radical interest groups. Like, if you wouldn't put this kind of BS language in here, you'd have a better chance of succeeding while hurting hardworking American citizens. Okay. The American people registered their verdict on the bloated, corrupt federal bureaucracy on November 5th. That's not right. That wasn't a verdict. By voting for Trump and his promises to sweepingly reform the federal government. Right. February 11th, the executive order implementing the President's Department of Government Efficiency Workforce Optimization Initiative commenced a critical transformation of the federal bureaucracy. It directs agencies to eliminate waste, bloat, and insularity in order to empower American families, workers, taxpayers, and our system of government itself. Now, it's kind of a beat. Oh, I know, it's so mellow. We appreciate that. Trump required agency heads promptly undertake preparations to initiate large-scale reductions in force consistent with applicable law. Trump also directed that no later than March 13th, agencies develop an agency reorganization plan. So I'm not going to go too much further into this memo because the memo is just saying we're going to do this, we're implementing this. Surviving. I'm trying. I'm doing my best. I'm doing what I can. Oh my gosh. Oh my goodness gracious. It's a rough road, but that's all right. It's the road that we're on. All right, so that's the memo. All right, let's dive back into what happened today with the Supreme Court then. Let's see how this is going down here. So again, 2 paragraphs. So let's reread through this. This is today. The application for the stay presented to Justice Kagan and by her referred to the courts granted. The May 22nd preliminary injunction entered by the court. So this was a preliminary injunction that paused that executive order. All right, everyone following me there? So that executive order 14210 had been put on pause. And they're asking for it to be unpaused, all right? Is stayed pending the disposition of the appeal in the United States Supreme Court. The United States Court of Appeals. So this preliminary injunction, it's following the same path. The district courts gave it. They appealed it to the Court of Appeals. And the Court of Appeals is like, we'll decide it whenever we want. And so in the interim, they asked SCOTUS to pull the injunction off. So we don't know if the injunction's okay or not because we haven't heard back from the Court of Appeals. What SCOTUS what SCOTUS did is they said, no preliminary injunction. We got to wait on the Court of Appeals. So that's the key here. A little closer. Sure. Let me see if I can get a little closer. There we go. How about that? Oh, no. I hope we're not bent to one side or the other. Oh my gosh. One of your nurses just absolutely, oh, that's so sweet. Oh, she was in the hospital. Oh, that's adorable. Oh, well, hi. Shout out to all the nurses out there. Thank you for your thankless job. We appreciate you. Better. Okay, great. Thank you, everybody. Yeah, just give me a heads up. I've got a new system here. So if it's not even or whatever, just let me know. All right, so that's what happened here. Everyone's following the path. All right, district court said stop. Court of Appeals said we're thinking about it. And then SCOTUS says you don't have to stop, is how that translates. All right, then we've got, and that's just what they're saying. So should cert be denied again? And then they're saying what happens to the stay if cert's denied. All right, hold on a second, everybody. I've got to bump this up just a little bit. Sorry, there we are. All right, there we go. It was kind of tipped to one side. All right, so district court's injunction was based on its view that executive order 14210 and the joint memo here are unlawful. So the court was saying, I think it's unlawful, so we're not going to be able to do that. I did not pull the preliminary injunction out for this case, so I don't have the deets on that. But we can take a look at the deets sometime. But they're just saying the executive order is not lawful, and therefore everything's on pause. Because the government's likely to succeed in its argument that the executive order and memo are lawful, and because the other factors bearing on whether to grant a stay are satisfied, we grant the application. All right, so they're granting the application for the stay. We express no view on the legality of agency RIF and reorganization plan produced or approved pursuant to the executive order and memo. District Court enjoined further implementation or approval of plans based on its view about the illegality of the executive order and memo, not on any assessment of the plans themselves. Those plans are not before the court. All right, so there we go. And then we have Justice Sotomayor, her concurrence here. Boy, my hands look really big now. Oh no, my hands, they're scared. My own hands are scaring me. Here we go. Yikes. Hello, John. Oh, you're so sweet. All right, here we go. So, Sotomayor, concurring in the grant of the stay. So, concurring in the stopping of the stop. I agree with Justice Jackson that the president cannot restructure federal agencies in a manner inconsistent with congressional mandates. Right. Here, however, the relevant executive order directs agencies to plan reorganizations and reductions in force consistent with applicable law. And the resulting joint memorandum from the Office of Management and Budget and Office of Personnel Management reiterates as much. The plans themselves are not before this court at this stage, and we thus have no occasion to consider whether they can and will be carried out consistent with the constraints of law. I join the court stay because it leaves the district court free to consider those questions in the first instance. Ooh, all right. So what she's saying here is that the executive order is just saying we want plans, and we've just read through it, and I think that's true. There's no actionable pieces to that executive order because they're saying gather information, put it together, prepare the reports, right? And so Sotomayor is saying, sure, you can do that. But when it comes to implementation, now we're going to have that question in front of us. So let's just double check here what they're doing and making sure. Here it is. So hiring ratio, they're saying there's a hiring freeze, which is already in place, which we already know is fine, apparently, because that's happened before with other presidents, right? And this one. And so we've got hiring approval. So they're putting a plan together for that. They're not saying they will hire. They're putting the plan to hire. Then we've got preparation of a report here, eliminating DEI information, which that actually, to do this piece, this could be brought actually as a reason to, depending on, all right, hold on everybody. Stay with me here, all right? By going through and eliminating anything DEI could potentially be its own rationale for another preliminary injunction. How they actually implement this, like gathering information on how to do it versus how they actually do it, are two different things, right? So this one could definitely be grounds for another preliminary injunction before they actually do it. Here, then non-essential people, which again, we don't know what that is. That could also be challenged in court. Rulemaking here, again, this should already be in place. And then we have another report being prepared, and then a report to the president, and then the two people here can make exclusions, so they can set that out. So this is a plan. This isn't an actual implementation. It looks like this is concepts of a plan. He's got some ideas of what he wants in the plans, but the order itself is just plans, all right? I think that's really important here. So that's what Justice Sotomayor is saying. She's saying we may have grounds for a preliminary injunction or for overturning or holding the executive order unconstitutional. We may have grounds for that. Perhaps not the executive order, but the actions because of the executive order, we may go forward on that. But right now, we're just saying, they're just saying put the plans together. Although again, so I'm coming in here, everyone, and I'm giving you both sides here. Because again, you might say, well, they can put their plans together, but with this administration, we do not have a solid faith or solid understanding that they're not going to start implementing things immediately. Who's to say they don't write the plan on a cocktail napkin and then everybody's heading over to El Salvador? See what I'm saying? See what I'm saying? The problem here isn't like, okay, let's just do step one and then we'll figure out what we do for step two. They can do step one, or at least attempt to do step one, and then they'll do whatever the H they want. Then, they'll like, boom, everyone's fired, rather than, well, where's your plan for firing everybody? That's what you're supposed to do under the executive order. You're supposed to have a plan put together. It doesn't say you can go forward and fire everybody. See what I'm saying? So there's this piece of where there's no trust, no way of believing they're actually going to do what they're saying they're going to do. Well, right. We don't trust them. And I think, and this is one of the pieces that I've personally been struggling with quite a bit, is any kind of allowance or I keep using the word faith. That's not the right word. What word am I looking for? Hold on a minute. Hold on. Let me pull it. Let me get it. Ooh, that's a good one. Hold on. Sorry, everybody. Credibility. The word I'm looking for is credibility. All right? They're not credible anymore. That's the word. Somehow that in my mind meant faith. So they've got no credibility anymore because of what has happened. Exactly. When you constantly lie, too much ambiguity, exactly right. Exactly. So, if we had a government that was not at a point where everything they said was perhaps true or not true, there would be a different story. But for me, I guess, because I see them screwing with definitions legally and saying like F you to the courts, like I'm not sure they've got enough credibility to go forward on any of it. Did they ever? Well, I don't think credibility is for every area of every government always. I don't think that could ever be the stance. But I think there's some basic understandings. Like even with George W. Bush, there were some basic understandings. Like when he and Congress put together the attempt to use the Alien Enemies Act, they attempted to do that. And the court came back and said, you can't do that. Like he complied with that order. Right? Like we didn't think at the time, well, George W. Bush is going to do whatever he wants. He's not going to comply and he's going to just, implement this even though the Supreme Court told him he can't. You know what I mean? Like we're at that level, or at least I'm at that level. Like I still had a belief that when he said we're not going to implement this way because the Supreme Court said you can't, that he would actually follow through on that. And I feel that way about, pretty much all the presidents, except for maybe Johnson and Jackson and Polk. Well, maybe there's a few presidents. Oh my gosh. Right. So that's the question. That's the thing. Hello, Upgrade. Good to see you. Can you say he was ever? Well, right. And was he ever credible? That again is another question. I'm not sure. Right. Our SCOTUS isn't checking this one. Well, that's part of the issue too, isn't it? It's a fundamental problem that we have with SCOTUS. And even when they do an order that seems appropriate, they're, whether or not it will be followed, we just don't know. So I think that's a primary issue here. Just be forthcoming and honest. Should be simple. It should be. It should just be basics. And, not even on everything, right? And I always use my example. One of my biggest disappointments of the Obama years, all right, one of my biggest disappointments was how he dealt with Guantanamo Bay, right? So how he made the determinations and decisions that he made were opposite of what he had said on the campaign trail. And honestly, I think we're absolutely horrific. And so that was like a huge letdown. So he lost a lot of credibility with that. And you can say that for all presidents, you know, that there's stuff in there that's going to ruin their credibility. But this question of whether or not he will actually comply with the U.S. Supreme Court, you know, that's kind of a higher level. At least for me, that's how I feel about it. To say about Gitmo, I know, true story. Nobody's telling him no now. Well, and the other thing too, everyone, and this is the pattern I've noticed, and again, even reading through what we've got here, and I'll jump into Justice Jackson's dissent here in a second, but even looking into this, and then going all the way back to 2019 and 2018, and looking and seeing how the Supreme Court dealt with stuff, they are answering the minutia and not answering anything else. So every step of this whole process, even in the immunity case, they're only kind of tossing out a couple of ideas, but refusing to rule on the actual issue itself. And, you know, even here, they're saying, well, we're not ruling on what the plan is. We're ruling on whether or not you can make the plan. So, I mean, like the dragging of the feet situation, kicking of the can down the road. And I keep thinking, like, are they going to keep kicking the can down the road? Like, what's going on, you know, with that? So that continues to be one of the things. And I think they're kicking the can down the road in order to keep everything from exploding. I think they realize they're only a couple of crap decisions away from, you know, everything completely imploding. Right. What are SCOTUS numbers for this? Oh, no problem. No, we've got Sotomayor has a concurrence paragraph. She has a concurring paragraph. She would grant the stay, so she's there. And then Justice Jackson over here is dissenting. All right. Now she, again, Justice Jackson, we adore her. We adore Justice Jackson's language and how she speaks. I also absolutely adore Justice Barrett's writing. Her writing is so easy for me to understand, and I appreciate it so much. So don't get me wrong about that. I think there are some really good writers here. This one's not a good writer. This one uses too many words, like calm down, you're not, you know, the Prince of Egypt here, fella. This one needs to use a few more words, but he's like, if I use too many words, I'm going to get into trouble. This one here's like, get to the point because I want to go have a beer. And then this guy's like, I've got stuff to say, but now I'm tired. Justice Jackson's like, hey, we want everybody to understand what the words mean. And then Justice Kagan is like, who's going to jail? So that's kind of, well, yes. So that's kind of the breakdown of the court here. Oh, yes, Justice Brown's amazing. So, or Justice Jackson is amazing. So we've kind of got that breakdown here. So I absolutely respect where she's coming from. I don't always agree with any of the justices, but I think she does a good job. Let me dive in here. And yes, I know what you meant. I know, Desert Skies, and I read that. And I was like, wait a minute, there's another name. Let me dive in and we'll kind of start here on Justice Jackson's dissent and see where she's coming from. And, you know, too, her dissent in the last case was on fire. And a lot of people were saying Justice Barrett went after her for her dissent in the last big case. But I would remind you, Barrett also went after Sotomayor, Kagan, and Jackson on the Colorado case. So Trump versus Anderson, she was hardcore. She's like, what are y'all doing disagreeing with us? That's not appropriate. And I mean, I would say Justice Barrett has a way that she thinks the more liberal justices should behave. And if they're outside of that behavior, she calls him for that. So I would say that's kind of a thing that she does. So of course, Charles. All right, so here we go. Justice Jackson dissenting from the grant of application for the stay. We've got, under our Constitution, Congress has the power to establish administrative agencies, right, and detail their functions, right. Thus, over the past century, presidents who have attempted to reorganize the federal government have first obtained authorization from Congress to do so. So she's saying, first, you need to go to Congress. The president sharply departed from that settled practice on February 11th, however, which is the date of that executive order, okay, everybody? However, by allegedly arrogating this power to himself, he does that a lot, with no mention of congressional buy-in. The president's executive order 14210 mandates a critical transformation of the federal government to be accomplished by eliminating or consolidating existing agencies and ordering agency heads to promptly undertake preparations to initiate large-scale reduction in force. This unilateral decision to transform the federal government was quickly challenged in federal court. As relevant here, the district judge thoroughly examined the evidence, considered applicable law, and made a reasoned determination that executive branch officials should be enjoined from implementing the mandated restructuring until this legal challenge to the president's authority to undertake such action could be litigated. But that temporary practical harm-reducing preservation of the status quo was no match for this court. Oh dear, she's getting spicy, everybody. Spice is coming out. Here we go. No match for this court's demonstrated enthusiasm for greenlighting this president's legally dubious actions in an emergency posture. All right, so let's pause for a minute. This is worrisome. This language that she is using is extremely worrisome. All right, now I haven't read through her whole decision, so I don't know all of her points. The reason this is worrisome, though, is not because of her stance on this case, but she's in there with everybody. She's listening, she's talking, they're debating, they're, having lunch or whatever, sharing the copy machine. I don't know what they're doing, but they work together. So for her to come in and use this kind of language here, that's what worries me quite a bit, is because she's got that backstage pass into what's really going on. So I would say, this case, yes, it's worrisome, but in this particular situation, I think it may very easily be her overall impression of the different justices that has pushed her into saying this. No, I don't think she's being antagonistic. I think this is just how she feels, and she's like, well, this is just the facts. This is what we're doing. Right. Thinking about total immunity. Could be. The other thing too, though, with Justice Jackson, and, again, if you listen to her questions on oral arguments for her case, for any of the cases, she doesn't want to deal with BS, and I adore that about her. She's like, let's get to it because we got stuff to do, and I appreciate that so much. So for her, she's just gonna, kick the door open rather than carefully open it. And that's more her style. So I'm not sure. We've got a situation where she's trying to be antagonistic. I think she's just stating what she thinks. Now, there have been many times where I have seen, oh my gosh, that can't be the same for Justice Sotomayor. She is incredibly antagonistic, and I have no problem with that. Justice Roberts, incredibly antagonistic, especially in my opinion, in the Dobbs case. Like, I'm going to need you to calm down, Roberts, in that. And then Alito, of course, is absolutely disrespectful to everyone. So, there are people on the court that are very antagonistic, for sure, but I don't think that's her purpose in this situation. With the horns, I had to change that. I had put horns on Alito, and somebody had a tail. I think Gorsuch. Is this her sounding an alarm? I think this is her she's no longer in that stage of kind of like, I'm a new justice, and so I need to be careful. I need to walk carefully until people get to know me, and then when I'm more comfortable being a justice, then I'll kind of let more of my insight out. And Thomas like didn't talk for 20 years. But I think Jackson just hit that point where she's like, I'm going to say what I'm going to say. And because it needs to be said, I think we're more in that phase of it for sure. I think she's just more comfortable now, just saying, let's put it all out there. That's my thought. That's my thought. I don't think she is sounding an alarm here, and because I think she has already sounded the alarm multiple times. I'm not sure this is the alarm. I think we had the alarm a little while ago. Her grace period's expired. Exactly, that's what I'm saying. That's exactly right. She's like, this is what it is now. Now we're moving on. All right, next piece here. The court has now, this is worrisome again, because she's got that insight. The court has now stayed the district court's preliminary injunction authorizing implementation of Executive Order 14210 and all the harmful upheaval that edict entails, while the lower courts evaluate its lawfulness. In my view, this was the wrong decision at the wrong moment, especially given what little this court knows about what's actually happening on the ground. And I think that's amazing. I think she's absolutely right. That the court doesn't know much about what's happening on the ground. And the other thing too to remember with Justice Jackson was she was a judge. She was on the bench for a while, and she's only been on the Supreme Court for a brief period. So so she's still in that judge mode. And if you look back to that district court judge, I'm sure Justice Jackson's like, I see where this judge is coming from. We don't know about that Court of Appeals decision, but she's probably in that same mindset. She's a judge. She's been a judge. And so for her, she's like, we're not listening to all of the information because we're up here in the ivory tower. And that worries me because I know it's going to be a problem. And that absolutely makes sense. So to be specific, what is that issue here is whether Executive Order 14210 affects a massive restructuring of the federal government, the likes of which have historically required Congress's approval on the one hand, or minor workforce reductions consistent with existing law on the other. Those are pretty extreme. One needs facts to answer that critical question, and that's the judge in her. That's the hardworking judge right there. She's like, we need some facts rather than just this, stuff you're sending to the SCOTUS. And the district court not only issued such a preliminary finding based on actual evidence, it's also the tribunal best positioned to make that determination, at least initially. Put differently, from its lofty perch far from the facts or the evidence, this court lacks the capacity to fully evaluate, much less responsibly override, reasoned lower court fact-finding about what this challenged executive action actually entails. So this is it. What she's saying here is the district court is better positioned to truly make this kind of a call, and that's been consistent for all of her arguments when it came to injunctions. For any of these cases where Justice Jackson's coming out and she's saying, look, this is better left in the hands of the judges dealing with it every day. And so that's where she's coming from. Meanwhile, the other judges are saying they're just putting a plan together. It's harmless, essentially. And she's saying, we don't really know because we don't have all the information. So, the district court didn't think it was harmless. So maybe there's something here. So you can see kind of the pull push that's going on with the case. For 20 years, because he was like, true story. That's very true, right? To Thomas, perhaps a bit. Oh my gosh, Chris, I tell you what, I still remember. Oh my gosh, I remember all of that because I'm an old lady, and I remember thinking, this is just awful. And how it was awful, but also the whole Anita Hill situation just opened the door to a whole new world for this country. I mean, we shifted. The whole country shifted after that situation. And so for that, I'm thankful. But absolutely correct. Absolutely. Although Thurgood Marshall, oh man, That fella, there's not many like that. Relive that, in my opinion. Oh my gosh, yeah. Well, and Kavanaugh, right? So with his beer drinking, and like if someone's even willing to come in and testify that there's even a question, like you need to get yourself, yeah, get yourself gone. Yeah, absolutely. Oh no, I knew what you meant, Jason. I knew what you meant. Gorsuch, whoo, he's got his own set of issues. Man, this one, he is the most arrogant, in my opinion. He's the most arrogant justice that I've seen since Scalia. That's saying something. All right, so back here to the dissent. I respectfully dissent because, in addition to the government's failure to show the exigency or irreparable harm that's required for emergency relief, this court could not possibly know in this posture whether the government is likely to succeed on the merits. And that had upset her too, because she's basically saying, look, you're calling us way before we actually have the information with respect to such factual dependent dispute, so it should have left well enough alone. And I think that's absolutely valid where she's coming from. And this really mirrors a lot of what she was saying too about the case where hold on a minute, I got to think of the exact words. There was a temporary protective, uh, what was it? A deferred, oh my gosh, everybody. The one where there was like 10,000 people, and they said there was promises that they weren't going to get rid of them. They were temporarily protected. And so they're like, well, we don't want that anymore. So they revoked that protection. And the court's like, yeah, you can revoke it. And she's like, what are you talking about? We've got 10,000 people here that are going to be on the streets, right? Like the practical piece of this, the practical implementation of this is where the problem is. That wasn't the best explanation that I could give, and I apologize for that. But you know what I'm talking about, you know what I'm talking about, the tens of thousands of people that were just going to be removed from the protective status. Oh my gosh. It's really going during Anita Hill, but I remember that. Oh my gosh, I know. Oh, it was terrible. They're in hoity-toity positions. That's exactly right. That's exactly right. Yes, the hearings were brutal. They really were. And, Anita Hill has written a book that has just come out. I don't, maybe when I say just, I mean within the last few years. And there's just so much great information. I mean, she's just an amazing human being. And I appreciate her so much in what she's done for the country. But it's really, it's hard. It's a hard period of time to go through. Hello, Boxer Mom. Welcome, welcome. So we've got some idea here of now what this case is about. The media has come out and said, well, the Supreme Court has granted permission to fire 100,000 or hundreds of thousands of federal employees. That's what the media is saying, right? That's not what the court is saying here. And they take it to the extremes so far because, of course, if it bleeds, it leads, right? And a lot of these cases where they're coming out with these decisions, and the birthright citizenship case, I think, really showed that. Where first there were reports like, that's it, birthright citizenship is gone. Like, what are you talking about? What are you talking about? This was an injunction question. And so by the time that actual information got out to the public, everyone was panicking because they thought that was it. Birthright citizenship's over. Like, no, no, don't do that. Yeah, exactly. Everyone fired, woohoo. Exactly. So, Mr. Trump's got his own issues going on, and he likes to kind of cherry pick what he hears and twist it, and that's fine. But now, you all know that this is about a plan to be done, to be organized, to be even given to the president on how they want to go about doing the reorganizations. All right, this is about making the plan. This is not a direct ability to go forward with the plan. That's a different executive order. That's a different thing. All right. So you all have the knowledge, and we can see too here where Sotomayor, I think, is understanding completely where Justice Jackson's coming from. She's got a lot of experience, and I think Justice Jackson at this point She's no frills. She's like, we're going to do this. This is how I feel about it, and we need to get it sorted. I think you went too far. And her number one priority seems to be what's in the best interest of the people. Like, it doesn't seem like with Justice Jackson, it's like what's in the best interest of the Constitution. For her, it's what's in the best interest of the people, and I think that really shows. Yes. Hello, Bill. Hello. Welcome, welcome. So I think that's a key piece here. She has dissented here with this, but everyone else has agreed to the stay, which just means there's no further pause on the order telling them to go forward and make plans. Oh, of course, you're welcome, Denise. You're welcome. Oh, yes, I'm sure they absolutely argue with each other behind the scenes. You can't get 9 attorneys and not fight with each other, right? You got the dinosaurs in here trying to tell the young ones, like, well, this is this and this is this. And then the young ones are like, I can't even understand the words you're using because they're so old. And then the others that are like, don't mess with me. I'm going to do my own thing. And then this one who's like, oh, fine. So there's a lot of that going on, for sure, for sure. They absolutely do. But there should be a base level of respect just from understanding the gravity of the job that they have to do here. So I think there's some of that involved as well. So with that, though, everyone, do you have questions here? I think we're kind of winding down. I've hit my about 90-minute mark, everyone. But I'm really hoping that this kind of clears things up for you. So when we're seeing if all of these employees getting fired all of a sudden, like, that's not what this was about. That this is about something else. If that's what the administration does tomorrow, that's what they do tomorrow. Oh, well, right, Boxer Mom, right. I feel like we know them, right? I feel like I've spent so much time listening to these people. I know them now. Very helpful. Good. Should they respect someone just because of the position they hold? No, and that's an excellent point. But I have to say, each one of these justices, less so the newbies, but each one of these justices has had a valid and acceptable, reasoned out decision that they have been a part of. They have made some decisions that are horrible, but they've also made some that are very important and have helped the country. So I feel like, that's something that if you're working with them, you have to weigh out for sure. You have to weigh that out. Like the bad situations here, don't get me started on Dobbs, but in other cases where we've had unanimous decisions that have gone the way that we needed them to go for the country, they've also been involved in that too. All right, so I'm not working with them, so I don't have to like them at all. I don't have to look at it that way because I'm not working with them. But if they're working, with them, you got to figure out a way to kind of come in and deal with it every day, right? Although a hostile work environment, hello, that's like a thing. I have no doubt. Oh my goodness. Oh yeah, Kaya. No, I know. I totally understand. All right, with that, my friends, I will go ahead and sign off for tonight. I'm so glad we were able to do our Tuesdays. Again, I'm really going to try to make sure I'm here Tuesday nights. That is my forever goal here. And I'm also working on a new series that I'm only going to be putting out here on the tube, everyone. I'm going to try a new, something new. I'm not sure how it's going to go, but I will be launching it pretty soon. So I'm kind of excited, fingers crossed. So a whole new series that's going to be coming out just for the tube. So make sure you watch some stuff when it comes out. Hopefully it'll be interesting and give me some feedback. So take care, everyone. I will sign off for tonight. I wish you all the very best. I will, fingers crossed, be back next Tuesday, of course, to hang out again and go through some more interesting stuff. So take care, and I will catch everybody the next time.